Hello, everyone, and welcome back once again to Immigration and Jobs Talk Show. I'm feeling great to be here today on a Friday and looking ahead for a very, very long weekend. But before we get to all that excitement, I would like to tell you that I'm Nipasa Pradhan and I'm going to be your host for today for an hour or so from now. And I'm thrilled to have you join us, whether you're watching us on YouTube, LinkedIn, Facebook. Thank you so much for joining. And let me tell you that this is going to be a very participative session as well. So feel free to put your questions in the comments. And
Oh no.
you agree and understand that the information, including comments and replies from users, is not legal advice. Use of information is at your own risk. So thank you once again, friends. Thank you for joining us. And yes, this is Immigration and Jobs Talk Show. And I think without further ado, like I was telling you, we're going to have a very intriguing session today as well. So our topic for today is curious about H-1B visas. So if you have any questions about H-1Bs, you are on the right path, on the right track, because we are going to have our guest join us today, none other than attorney Justin Rivera. Please help me welcome him back here. How are you doing, Justin? Thank you so much for joining us.
I'm doing all right. The weather's a little bad here, so I'm just giving you a heads up. So if there's any connectivity issues or anything like that, it's because of there's a thunderstorm rolling through right now. But hopefully that doesn't create any problems. But other than that, I'm having a great Friday.
Me too, and I'm excited for the long weekend.
Hmm. Absolutely.
All right. Yes, yes. And so, Justin, dear friends, he is an employment based immigration attorney. And, he has been working with Wasden Immigration and Litigation. So, how has it been so far, Justin, with
Uh, it's
Wasden?
it's been great. I think finally settling into the role, which is nice, and really enjoying it. Working on different cases from what I used to work on at my former employer, so it's nice to see a bit of variation, and everything's different. At least I feel like I get a lot of different kinds of cases to work on, and I'm enjoying that. I'm enjoying the challenge.
Great, great. So good to have you here today as well. And I'm looking forward for this whole intriguing session full of exciting discussions and I'm sure questions also. So let me tell you that this is an Ask Me Anything session. So friends out there, you can ask Attorney Justin Rivera anything that you have, especially with regard to the topic, and that is H-1B visas. So before we dive into the discussion, it's important to also acknowledge the latest updates in the immigration world. So, Justin, maybe if you have anything to give out before we start off with the questions.
Yeah, I mean, not a whole lot, and for me at least, I would just, I mean, just kind of speaking on what I've been working on recently. I've definitely seen quite a few issues coming up with people's STEM OPT applications, with issues with violations of their OPT status at their former
Mhm.
employers. So, obviously, you need to be cognizant of those 90 days of unemployment for your OPT status and how failing to adhere to that can render you ineligible for the STEM OPT extension. I've been seeing a couple of those cases come in. And a couple other things I've been working on, just generally speaking, and really this actually kind of ties into the H-1B stuff today. So I very recently saw someone, and I think that this is important to discuss because they were actually all the way at the end of their immigration journey, where they're scheduling the I-485, where they're attending their I-485 interview, and during that interview, they actually ended up telling admitting, because it's what happened, the officer, that they had actually been working from home. And the issue with that was that home address was not covered on the labor condition application. It was not in the LCA, and it unfortunately was not in the same what's called metropolitan statistical area, meaning that it was not technically permissible employment. So this person, they didn't realize it. I mean, this person was completely guiltless. They never got a copy of their LCA from their employer. And they never
Okay.
realized that their end client, when authorizing them to work from home, had not talked to the employer about it. So this person had been working for
Okay.
years, 4 years, a full H-1B and an extension, not
That
realizing that they were completely violating the LCA. And so they go for their I-485 interview, and they ended up getting a notice of intent to deny on their I-485 based on the idea that they had violated their H-1B status for a period of more than 180 days. And it's crazy to think about. Imagine you wait all that time in that backlog to get to this point, and the process can be messed up as a result of a mistake that you didn't even realize was a mistake. And so that was just something that really makes me think that we need to do a better job of ensuring that the non-immigrants here in the U.S. that are going to be on H-1B status, that they are aware of these pitfalls, of these issues that could occur. So, I mean,
Mhm.
always you're entitled to a copy of your labor condition application as a right. Failure to do so is failure to comply with DOL by the employer. So always make sure that you have a copy of your LCA if you're an H-1B employee, and make sure that you are working in the area that you say you are, because it can come back to bite you. I mean, this person had no idea this was going to be a problem for them. They were just saying what they've been doing for the last few years, and now they're staring down the barrel of a notice of intent to deny that adjustment of status.
It's crazy. It's crazy. And you deal with all these sorts of complicated cases very
Yeah.
regularly, Justin. So I wonder, what do you do, to keep yourself sane, mentally? I mean, apart from your own life and everything, you also have these things to solve. So what do you do?
Mm. Just long walks with my dog.
That's
It's
lovely.
a way to think.
Discuss your cases with
Um,
him.
yes, we frequently discuss the cases, my dog and I.
That's sweet. That's sweet. Well, friends, this is an Ask Me Anything session, and the topic today is curious about H-1B visas. So I think, Justin, I am ready. Are you ready to take up questions?
Sure. Yeah, absolutely. I know we're on a tight schedule, so.
All right. So we have Priya with the first question on YouTube.
Mhm.
Hi. While booking for H-1B visa stamping, I answered no for a question whether I held any previous visa other than B1 or B2, which should have been yes. For this, I was not given Dropbox option. But the portal took me to interview option and I was able to book one. I know that it's not possible to change it in the application now. Is there any way I can write to the consulate of this mistake, or will it be a problem while going for an interview for this wrong answer?
So I think if you want to be super careful, what you can do is fill out another DS-160,
Mhm.
and just fill out and bring another DS-160 and explain that you're correcting a mistake in a prior submission. I think that's being as careful as possible. Consulates can vary based on what they want someone to do, so you can also try contacting the consulate first. But I definitely think that I think that the safest thing to do would be just go ahead and do another DS-160, correct the error, bring it with you to the interview, and admit it up front that you made a mistake on a selection of something, and then say,
Mhm.
here, it was my fault. Here's this, and then that's all. Because I really don't think it's that big of a deal, especially if you're admitting up front that there was a mistake that you made in the DS-160. I don't think it's necessary. I mean, don't cancel the appointment and make a new one just based on that, because then you're paying the fees again and everything. Um,
True.
so I definitely think that would be the easiest course of action. Just or take a new DS-160 to the interview, because I don't think they'll let you
Mhm.
submit it.
Okay, but it's always important to update, I mean, it's good that you are admitting the mistake and updating it as immediately, I think is always good. That way you're safe no matter what.
Yeah, and
I
I mean,
mean,
it's a
instead of
B1
just,
B2 visa doesn't carry work authorization with it or anything, so I
okay,
wouldn't think it's that big of a deal. But at the same
okay.
time, you do want to be upfront. Consulates are different, but for the most part, the consulates I've dealt with, the officers aren't there to get you. to put you in a situation where they're going to give you a 221G or deny you.
Okay.
They're more so just looking to figure out whether or not you qualify and that you've answered truthfully. So I think it goes a long way to just admitting the mistake up front and then providing a new document to replace the old one.
Cool. So, Priya, thank you for your question. I hope you got your answer. And thank you so much, Justin, for
Mm.
taking that out. Uh, we have short. What does the student studying on USA on F1 visa require to convert the visa from F1 to H-1B visas? Is that the
Um,
question?
So I
Yeah.
think that if I could kind of generally spin this in like what is it that you should look for if you're an F1 going to H-1B? I think
Mhm.
for the most part that's going to be people who've been selected in the lottery. So if you're selected in the lottery and your petitioner's filing an H-1B for you, they file it one of two ways. They can either do change of status or consular notification. So change of status is going to mean that you convert to that H-1B status on 10-1 typically, because that's going to be the first date of eligibility for the status. When you file a change of status, that means that sorry, emails. When you file a change of status, that means that your time spent in your current non-immigrant status is going to be reviewed. And so what that means is if USCIS determines that there has been a violation of that status, then your change of status can be denied. Now, the change of status being denied means you can no longer change status to H-1B. You now have to depart the United States, go abroad, attend a visa interview, and come back in with an H-1B stamp. So it does mean that you need to look out for certain things. If you're on F1 and you're on OPT, you need to look at your
Mhm.
unemployment dates to make sure that it hasn't exceeded the threshold, which I believe is 90. And then when you go into STEM OPT, it's a larger number. Don't quote me exactly. I believe it's 120. But you need to look out for those dates, because if you have violated that, then you may want to consider filing consular notification rather than risking your change of status being denied and carrying with it any penalty as a result. That's usually the big hurdle that I've seen for F1 change of status. The other thing that I have definitely seen is the day one CPT issue. And just kind of generally touching on that, that's where someone will maybe have exhausted their OPT and they enroll for a second major, maybe at another university. There's a lot of universities that I won't specifically name, but I feel they're definitely on a list of day one CPT schools. They're kind of, if I remember right, in Kentucky or around that area. But there are schools that kind of seem like they're day one CPT hubs. So when that comes up, if you're a day one CPT person who's at the same degree level, you might see an RFE where USAS alleges that you violated status because you shouldn't be doing CPT after OPT at that same degree level. So those are two issues I think that you would need to look at when you're filing your change of status. Hopefully, you're working with an immigration attorney that's well versed and is able to pick up on those issues at that time so that they can maybe advise you against filing a change of status.
Mhm.
I know that people sometimes want to hedge and file a change of status and see if they get an RFE and then maybe try to convert to consular notification then. I've seen that work. I've seen it not work. It's really just dependent on what your risk threshold is. I would always
Yeah.
say, the safest course of action is the one that carries with it the highest probability of a positive outcome. So I would probably lean towards just doing whatever's the safest. But each person's different, and you're going to look at those factors. I think that was a very long-winded answer, but I did my best to kind of make an answer out of that.
You did cover, and I'm sure, short, that was very helpful. Please comment if you have more questions, and even if that was something you resonated, please comment. It'll be good to know.
Hmm.
Moving on, let's go on to the next question we have. This is Akash. I have a query regarding attending H-1B visa interview for the 2024-25 round. Currently, I live and work in Germany, so can I attend the interview from here and the stamping done, or shall I have to visit my home country? Also, for dependent stamping, which would which would be the preferred one, and what are the pros and cons for getting done together or separately?
Okay, so I think as a general rule of thumb, the easiest place to go for your visa interview is your home country. Almost always. It's going to be the easiest, the most simplistic course of action is going to be going through your home country. Now, is it possible to go through another country? Yeah, it typically is, and they're likely going to let you schedule an appointment. Um,
Mhm.
Third party nationals, so someone who's not a citizen of that country, they may be kind of put at the back of the queue for scheduling purposes. So you may see an issue when you try to schedule an appointment that it's going to take you much longer than it would in your home country. But
Okay.
you can do it. Now, what is the pitfall of it? The only risk or the scary idea is if your visa gets denied, right? And if you're stuck in
Mhm.
that country and it's not your home country. I assume this individual who's living and working in Germany, they're authorized to be there. They have a German work visa or something. I don't know German immigration, so I won't speak to it. But their
Mhm.
pitfall would probably not be as big a deal. I think the people who I always recommend going to your home country for are people who are maybe like, I'm visiting country X and I'm going to go for my visa appointment. And it's like, all right, well, if you get denied, what are you going to do? Are you going to end up stuck in that country? So I would say,
Mm.
yeah, you can schedule. I always recommend doing everyone's appointments together. I don't recommend separating people's appointments. Just get it all done at the same time. I don't
Okay.
know if it's a psychological thing or what, but I just feel like when you bring your dependents with you to the appointment, you kind of show, I don't know, maybe the officer's going to be a little more like, oh, okay, inclined to approve that person. So yeah, I mean, I would do them together when you can. I just really don't see a reason not to.
Mhm.
If you have to do them separately, it's possible. Obviously, you've got to get your H done first before your dependents. So I would think you'd have to take that into account during scheduling. But yeah, if you can all go together, just all go together. It's much easier to do it. Now, that being said, there are some countries that actually allow people to not bring children that are a certain age, under a certain age. The children are not actually required to attend the appointment. So I would look at the instructions on your visa appointment to see if your kids might qualify for not having to actually physically appear, and you can just bring their passports with you.
So cool. So,
Mhm.
Akash, I hope you figure out. And thank you so much, Justin, for taking that up for Akash.
Mhm.
Let's move on now to this next question we have from Shruti on YouTube. She's asking for a friend. H1 was filed by current employer. A job is not directly related to the major of study. Would there be any issue during H1 transfers?
Yeah, I mean it it all depends on the officer
So,
reviewing the case. Um, but if you have a position that has not had what I like to call a nexus tied between the employment and the degree of the individual. There's no connective tissue
okay.
there. Um, when that's not apparent, then you can get what's called a beneficiary qualifications RFE. So that's going to be a
Okay.
request for evidence from the service where they're basically asking, how does this person qualify for the position based on their degree? Um,
Mm-hmm.
Hopefully you've sussed this out at the outset as a possible issue. The first thing I would recommend, if possible, is look at the actual specific courses taken by the individual and maybe try to explain how those courses give the person the qualifications for the position. Perhaps the position is a hybrid, something that
Mm-hmm.
crosses different fields, IT and accounting,
Maybe.
business and science, something like that. So that's one way you can tackle it. Another way is what's called a combo eval. So that's where you're looking at
Mm-hmm.
combining education and employment experience into an
Okay.
evaluation that shows that the person has, based on the combination of their academic experience and their real life work experience, they have the equivalency of a degree that's in a relevant field. Um,
Mm-hmm.
Usually for that, you're probably looking at It really depends on the case, not to be too specific, but you'd like to have 3 years of work experience, I think, traditionally. Sometimes you may even need as much as 6 based on what the degree is. Again, that employment's going to need to make sense too. It's going to need to be rationally related to what the person's doing. When you
Yes.
request the evaluation, you should have experience letters from an authorized
Mhm.
representative of the company who's willing to speak to not only the position and the duration that you held the position, but also, if possible, explain maybe the job duties or projects that you worked on. Because really, what you don't want to do is allow the officer who's reviewing the case to look at that
Mhm.
evidence that's supplied and be able to poke holes in it and say, well, this is, you said you worked 3 years at Google. You have a letter with a sentence that says this guy worked at Google. What was his position? How long was he there? What were his job duties? Who was his supervisor? There's all
Yeah.
these things that they could look at. And you have to understand, with the H-1B, once there were the third party placement memos, once those got revoked, which, just for a quick understanding of that, is, there were memos that came out during the Trump administration saying if you work at a third party, you got to show proof of contracts, employer, all this stuff, right? When those got revoked, it
Mhm.
really kind of made it to where USCIS can only look at, for the bit for an H-1B, the H-1B position. Does it qualify as a specialty occupation? And the beneficiary's qualifications. Does the employee qualify? So they're going to look at those hard because it's really all they can poke holes in at this point.
Mhm.
So again, I would definitely say, look into getting an eval. Some employers like to wait and see if the case gets approved. That way they don't have to worry about getting an eval unless there's a request for evidence.
Mhm.
That's an option. I like to present the strongest case possible up front to minimize the cost of an RFE. I think most firms probably operate in the same vein, where the filing is probably less than the RFE, because the
Okay.
RFE is going to be more tedious and time consuming. Um, so, yeah, I would say, look into getting that eval. I do definitely think that if you're working with an immigration attorney, that's going to be identified prior to filing. I mean, it's not likely that they're going to be surprised when they get the RFE that
Mhm.
your degree in business management did not qualify you to be a data scientist. you know so
Mhm.
yeah, that's it really. Those are really your only two courses of action, and then hopefully one of them works. If you don't have that requisite, I'm sorry, my nose is itching. If you don't have that requisite work experience, you're going to have to try and tie your education. And if you have a master's and a bachelor's degree, you utilize the totality of it. Pull everything out of both of those degrees to create that nexus, and hope for the best with USCIS.
All the best, Shruti. And thank you for your question. Thank you, Justin, for taking that up.
Sure.
Now, this next one is from Mahinder, also on YouTube. I am a Canadian PR and Indian citizen, but my H-1B got picked and approved. Do I need to travel to India to get it stamped from US consulate office, or can I look for an appointment in Canada's US embassy, say Toronto, Vancouver, Ottawa? Also, I have USA visitor visa. Can I travel to USA on a visitor visa next month and do a change of status to H-1B after October 1st?
So I wouldn't recommend the second course of action, just generally speaking. I would, since you're outside the US, I would just go ahead and get your H-1B visa stamp taken care of. The same issue, I think, that comes up with the individual who's in Germany, I think applies here to the Canadian as well. I would see if you can schedule a visa appointment in Canada, and if possible, see if you're able to schedule one. I think you should be able to. And then I would just go to your appointment in Canada. My one thing would be, I'm not super familiar with the wait times there, and I
Mhm.
don't know if there's going to be a difference for you as a result between how long it takes to get an appointment in Canada versus in your home
Yeah.
country. So I would just look at that. But I think I would just go ahead and try and schedule a visa appointment in Canada and see if you can get it done. Unfortunately, what's frustrating about scheduling your visa appointments is you can't look at the schedule until after you pay, which has always annoyed me, because it's very
Yes.
frustrating to be like, no, you have to put the money down and then we'll open the books and show you how long you got to wait for your appointment. I always feel like you should be able to look beforehand, but I don't think they're going to be making that. They're going to be making that change anytime soon.
Seeing is believing, they say. And
Right. Well, I mean, because you want to ideally be able to forum shop. Like, if you think about it, if you're somebody who's stuck in Canada, if you're like, oh, in Canada it takes 5 months to do a visa appointment. In India, it's in 2 months. Then I'll just schedule it in India and pop over there. But it puts you in a situation where you have to pay the fee in Canada to see those appointments, and then you have to pay the fee in India to see those appointments, because you also have to
yes,
factor in that all of these consulates in different countries are operating on different websites. Like,
mhm,
you're not really using the same universal system. And just to give you guys a peek behind the curtain, as someone who did a lot of visa appointment scheduling over the past year, I have no problem saying that India has the absolute worst one.
okay.
I'm sorry, you guys have the worst website for visa appointment scheduling. I have never struggled more with getting kicked out, with having things not go through, than I do with that website. It is just atrocious. It is horrible. Anyway,
I really hope
that's.
they have some good updates and upgrades. Yes, that's much
Oh, I
needed.
mean, they
But
knock it down for maintenance like every 2 weeks, or at least it used to feel like it when I was scheduling visa appointments. It felt like they kicked it for maintenance every 2 weeks. You couldn't do anything for 4 or 5 hours because they were working on it, and then you'd go in and it
that's
would be just
disappointing.
as. Yeah, it's very fresh. Like, the idea that if you're from India, you have to deal with a lackluster website just by virtue of that being your home country. It just frustrates me. I remember scheduling for people in South America, like Brazil, Argentina, Mexico, 15, 20 minutes to schedule an appointment, if that.
Okay.
Versus
How long do you take
sometimes
for India?
sometimes an hour and a half. Because it's just, you get kicked, your information doesn't save, and it's just so frustrating. I don't get why there's not uniformity to it, and everyone just doesn't have the
Mhm.
exact same type of system. But anyway, that's my rant for today.
Well, we'll take that, but I do hope that, there will be good upgrades very soon. And Mahinder, I would like to say that, sorry, am I? I would like to say that, you can contact attorney Justin Rivera directly as well if you want to have a one-on-one with him. Why not
Sure.
call him instead? And you can call him on this number. You can note it down. 844-592-7336. That is his number. You can even email Justin at support@wasden.law, and definitely go visit wasden.law to get to know more about Justin Rivera and, of course, Wasden Immigration and Litigation. Well, Justin, now I think we should move on to another question from our audience. Let's take
Mhm.
up Rahul. I'm seeking clarification on H4 visa travel regulations. A family member's spouse is in India with an H-1B visa, while their wife is also in India with an H-4 visa. They both recently traveled to India for urgent matters, but now the wife wishes to return to the United States alone. Can she travel back to the US on her H-4 visa independently without her husband's accompaniment since he remains in India?
So there's a heightened level of risk in that you typically want the primary to travel with the dependent, or the primary to already be physically present in the United States. So I definitely think that there's an added risk to that. Is it impossible? It shouldn't be, but I do think that you need to take extra steps from a documentation standpoint. So what does that mean? I would go so far as to carry a copy of the spouse's H-1B approval notice, maybe even a copy of their petition, and maybe even an updated letter from their employer stating that he is coming to work imminently in the United States, but he's not able to be in the United States right now due to X. Urgent family matter, business matter outside the country, something like that. So I would do that just to make absolutely sure that you're okay with coming back, especially if they've come in and out of the US already a couple times, then it's easier. But if it's a first entry on a new H4, then you
Mhm.
really should have the primary with you. And if not, take all those extra steps and hope for the best. If you want to be as conservative as possible, though, I would travel together.
Great. So, Rahul, I think definitely they should travel together. Thank you for your question. And thank you, Justin, for taking that up. I think it's time now to take a short break, Justin, if that's okay with you as well.
That'd be great. Thank you.
All right. So, friends, don't go anywhere. Today, we are discussing if you are curious to get to know more about H-1B visas, drop your questions. It's an Ask Me Anything session, and we'll be right back after this short break. So, don't go anywhere. Stay with us on Immigration and Jobs Talk Show.
Consultant seeking a new opportunity? We offer job placement services for US citizens, green cards, EADs, and visa holders. We also sponsor various work visas like H-1B, E3, TN, and green cards. 20 plus years of experience in the industry. Exceptional employee benefits. Highly rated by our employees. Global presence with 200 plus recruiters and direct clients. Connect with us. Call us in the number 408-335-6444 or mail us at nipa@higheritpeople.com or visit our website www.higheritpeople.com.
Hello, everyone. Welcome back once again to Immigration and Jobs Talk Show. And this is the second half of the webinar we are having right now on this topic. If you're curious about H-1B visas, get your questions answered by the attorney, who is none other than our guest for today, Attorney Justin Rivera. Thank you so much for joining us all the way from Wasden Immigration Litigation. And friends, it's lovely to have you here with your questions as well. It's been interactive, and you can keep commenting wherever you're watching. We are streaming live on YouTube, LinkedIn, and Facebook, and it's been great having your questions. So recently, we've seen an increase in RFEs and NOIDs or NOIDs for H-1B applications, especially in the wake of the heightened scrutiny under the current administration as well. So, but then also we also have the new fiscal year that's coming up starting October 1st. So a lot of you may have questions, and before we start off, maybe Justin, do you want to say anything on that too?
Yeah, I would love to if you wouldn't mind giving me a soapbox. So yeah, a lot of you are going to be changing status on 10-1 to H-1B. That carries with it different requirements and conditions than you're used to probably on your old status, which I know for a lot of you is F1. Maybe it was something else. But I would definitely say for those of you that are going to be moving over to H-1B, make sure, like I said, kind of at the top of the call, that your work is in compliance with your labor condition application. Make sure you're working where you're supposed to be working. Make sure that if you move work sites, that you inform your employer, or your employer, speaks with you. You guys come to an agreement, and you make sure that you guys determine whether or not you need to file an amendment. A lot of factors go into whether or not an amendment should be filed, all the way from the work location to the wage level to the SOC code. So there's a whole bunch of new considerations that you're going to need to deal with as a result of moving to H-1B. But for the most part, it's a smooth transition. You should start off right there on October 1st in H-1B status. It's never too early to start thinking about perm, if that's something that you're thinking about once you max out at that 6 years. So I would definitely take that into consideration too. Once you're starting working. Another thing, just kind of generally speaking, on that kind of has come up over the past couple of years that I see in things like consultations and stuff like that. Sorry, my email's absolutely blowing up right now. I apologize. Something I do see come up: transfers, H-1B, change of employers. Sometimes you join an employer and you start working with them on H-1, and it's a couple weeks in and it's not what you wanted or expected, and you think, can I move employers? You can transfer, but just remember, if you're transferring and you just started an H-1B, you have to show that you maintained status. And typically to do that, you have to be able to provide pay stubs. So I always recommend at least having 2 to 3 pay stubs available when you move employers. So I would definitely say be cognizant of that in the event that you start working with your H-1B employer and you don't like the situation and you want to move. Is it possible to change employers sooner, than the 2 to 3 pay stubs? Maybe, but I wouldn't take the risk if you don't have to. And so that's kind of the things that I think about most often is those quick change of employers, maintaining H-1B status, and then just making sure that you're in compliance with your LCA. Making sure, again, that you're working where you're supposed to be working, performing the duties that you're supposed to be performing, and being paid the correct wage. Obviously, the point of that labor condition application is to ensure that you're being paid with what you're supposed to be being paid based on the type of job you're doing and where you're working. If you're not being paid the wages you're supposed to be paid, you do have the option to report the issue to the Department of Labor, to the DOL, and the Wage and Hour Division can open an investigation as needed. Hopefully that's not the case for anybody, but it is something that can be explored, because obviously we don't want bad actors in the H-1B program. We don't want employers that are not paying people what they're supposed to be paid or trying to circumvent the rules.
So true, so true. So thank you so much, Justin, for the update. And also, like friends, I'm sure you also have questions. So, and if these changes are going to impact your H-1B status or your plans to apply, you might as well ask your questions because we're going to be here for some more time. And yes, we are discussing about H-1B visas. So I think quickly we will take up this next question now from Shri. Uh, Shri is asking, I'm currently in India as my H-1B 6 years maxed out, term awaited. Company will be filing 7th year extension next week. Question is, can we file H-4 EAD with 7th year extension from outside the United States of America?
I don't think you can file an H-4 EAD without an I-140, and it doesn't sound like you have an I-140.
Okay. So do you
That's it.
have an I-140, Shri? Tell us
It doesn't
about
sound like it if his perm's pending.
it.
So no.
So does he have any options?
Not for an EAD for his spouse. He has to wait for the I-140, his I-140 to be approved.
Okay.
So I mean, it needs to be
We need
filed.
to get that done.
Mhm.
Thank you, Justin. Now this next one is from Imran, also on YouTube. I raised FOIA request. USCIS conducted search for I-129 document and didn't find it. They provided me a note saying no records found. My H-1B got approved recently on April 25th, 2024. I requested them to provide I-129 and I-797. I provided my receipt number and they replied they can't find any documents. Does it mean my employer provided me someone else's receipt number?
I have no idea, man.
Crazy.
I mean, look, what it sounds like is your employer just gave you a receipt number. There should be receipt notices. You should have received a receipt notice, and if your H-1B was approved, you should have received an approval notice. If you don't have those things and they weren't supplied to you by your employer, I don't know, man. They may have not filed an H-1B for you in the first place. Yeah, absolutely. That seems very nefarious. And especially if you're claiming that you submitted a FOIA request and the government wasn't able to turn over that information because they're saying it doesn't exist. I've gotten FOIAs back where they'll redact portions of information saying, they can't provide this for this reason, this reason, this reason. But I don't think I've ever seen somebody come back and say, we just flat out can't find this record. Yeah, man, that's a new one for me for sure. And I definitely think, sorry, I don't mean to laugh, but it's so ludicrous to me that the employer would have given you a fake receipt number or the receipt number of another person. That seems bizarre. But yeah, I would definitely say if you didn't get a copy of your receipt notice or your approval notice, I would be very worried about whether or not you have work authorization right now or whether or not you're in the correct status if you're in the country. And if you're out of the country, I would wonder whether or not your employer actually filed for you in the first place. I think I would love to know more facts about this because, if this is someone who registered in the CAP, can they show that you had a registration notice that was selected? Was there, do they even have the ability to produce that to show that they even registered for you in the first place? And then I would go, if they can't even produce that, no, they never filed anything for you. So yeah, that's wild. I
Yeah,
mean,
sad to say. Yeah.
what's crazy about that is, I guess I'm kind of just spitting like hypotheticals. I mean, why would you do this? Maybe you have this person working on F1 status on OPT or STEM OPT, and you want to keep them employed. And you're claiming you're filing for them, but then you didn't really. But to take that lie and extrapolate it out to the point where you're giving them another person's receipt notice is bizarre. That's a case of first impression for me. I have never heard of an employer doing that before.
Imran, I would say it's a little unfortunate right now, your situation, but I think you should go do a thorough investigation, find out all these things which Justin just mentioned and
It sounds like
see
he
if it's
tried.
really, yes.
I mean, if they're, I just from my experience, if you're coming back saying your employer's not providing you anything and you did a FOIA request and they're claiming that there are no records available, then that's why I would say, have you tried putting the receipt number into the My USCIS case status, maybe, and seeing if that's an option? That would be my thought process. I don't know.
Okay, Imran, maybe we need more information about you. You could tell us more, or better
No,
even just contact
send an
attorney.
email.
Yes,
Yeah, send an
best to
email.
send an
That's
email.
such a nuanced case that I wouldn't even want to discuss that in more detail on the call.
There you go. So please mail him at support@wasden.law. Thank you for your question, by the way. All right, let's move on now to this next one. This is from Ishwar. Ah, okay, from Drive 10. Hi, Justin. Do you think the court ruling allowing H-1B spouses to work could hurt American workers? What's your take on this concern?
I've heard that idea, that posited the idea that allowing H-4 EADs can be harmful to the U.S. job market because the H-1B visa has more stringent requirements. You have to go through a lottery. You have to have a specific degree type. All this stuff. But H-1B, it's a different burden. And H-4 EAD you can do anything with it. An H-4 EAD, you can be self-employed. You can go work for a business. You can open your own company, whatever. I don't think that the H-4 EAD is harmful. I actually think that, first off, you're not just entitled to an H-4 EAD. The H-1B holder has to get an approved I-140 first. So there's already hurdles that exist. I think I've talked about it before here, but I will once again tell the story of someone who I actually had a case for, who was Canadian, and he and his spouse were going to come to the U.S. He had been selected in the lottery and got his H-1B approved. And once he found out his wife was not entitled to work just on the H-4, they actually didn't come. They ended up staying in Canada and working because his spouse made more money than him. So it literally didn't make sense for them to come to the United States. They would have harmed themselves financially by coming to the U.S. So I actually think that it can be a hindrance to not permit that immediate work authorization. You look at it as opposed to the L1, the L2 dependent spouse for the spouse, the visa carries with it automatic work authorization upon entry. You're able to just begin working once you come into the country. It's incident to status. So I think that there are already kind of like hurdles in place to even get the H-4 EAD in the first place. I just don't see how it can be that problematic for the U.S. economy, for American workers. I can understand some of the argument. The whole point is the H-1B is governed by a labor condition application. The LCA exists to make sure that people aren't working on low wages replacing U.S. jobs, right? And then the H-4 EAD doesn't have that on it. But I think that it's important to ensure that there's an avenue to employment for people's spouses, because if there isn't, you're going to have like situations like my case where you have people from other countries who don't come to the US because then they don't have that opportunity for their spouse to work. And so, and I think you want to keep, my opinion of immigration has always been you want to keep people here that have utilized the institutions here. People that have come in here and gone to school here and gotten education here, I think you want to keep them here because what's the point of educating them if you're not going to utilize what they've learned, and put them into the job market and put them into the labor force? I really don't think it should be harmful. Do I think it will limit opportunities and raise anti-immigrant sentiment? I don't. Sorry, I'm looking at his follow-up statement. I really just don't think. I really don't think that the H-4 EAD is the end-all, be-all on which people are willing to die on, as to whether or not they are anti-immigrant. I think it's something people maybe can point to if that's an issue that they have with legal immigration. But overall, I don't think that somebody is. I don't think. Long story short, the H-4 EAD is a good thing. I think it's a benefit. I think it's a way to keep people here in the United States while they wait in a backlog when their I-140 is approved, while they wait for the opportunity to adjust status as an avenue for them and their partner to continue working in the United States. I don't think a country like America that was founded on the ideals of, having a competitive workforce, having a melting pot of people, I don't think that there's any problem created by that just because you're letting an H-1B holder's wife work. I really don't see the drawback in it whatsoever.
Thank you so much, Drive, for your questions, and I hope you got your answers. Thank you, Justin, for elaborately taking that up as well and answering to Drive.
It's okay. I mean, I think about it because I started practicing immigration law about 2016, 2017, around that time, and I think during that time, I have almost on a yearly basis seen some sort of animus exist towards the H-4 EAD. And I just don't see the logic in it. I think it's ridiculous. I think, well, what is the alternative? You would rather that person's spouse not be able to work in the United States? They're already living here. Why not give them an opportunity to contribute to the workforce? I'm sorry. I'm done with that. All right. Sorry.
That's cool. But thank you so much for your answers and for elaborately explaining every situation. So, Drive, thank you for that interesting question. Let's move on now to this next one we have. This is from Galela. ISM on L1B expiring on September 2025. I got H-1B selection and opted for consular for change of status. Can I request start date on 1st January 2025?
I'm sorry. I don't think I understand that question.
I
Because
am
first
on
off,
L1B.
if your L1B is maxing, then your H1B is not going to work because you could have that extra 1 year. So you could have 1 year left. Okay. Change of status for same company. Okay. Yeah, sorry, I'm a little confused by this question. I'm going to take it in the way in which I think it is going to be, which is where you're trying to kind of use that extra 1 year for the H going from the L1B to the H1B. If you were selected in the lottery, your first date on H1, I believe, is 10/1. If you're changing status. I don't think you can delay the change of status, but at the same time, I could be wrong. I've never seen that happen. I don't think it will. I think if you were trying to delay your H-1B time, you should have filed consular notification and then, leave the U.S., go get a visa stamp, and then come back in because you're trying to maximize that time in H-1B status, if that's what you're saying. So yeah, I think you're going to be changing on 10/1, but you know what? I could be wrong. That's not something I've tried before, so don't quote me on it.
Okay. Galela, all the best. And if you have more questions, I think it would be best to email Justin. You can mail him at support@wasden.law.
Yeah, please.
Right.
I mean, if I could look into it more, it'd be great. Might be able to give a better response.
Yes, for sure. And now the next question we should take up is from Anabia. What are the consequences of a layoff or job termination for an H-1B visa holder? And what are the options for maintaining legal status?
Yeah, this is a great question. It comes up a lot. Unfortunately, layoffs do happen, terminations do happen. In that circumstance, with the H-1B visa, you have options. It's not an immediate issue where you're immediately out of status.
Okay.
The regulations allow for 60 days to either change status, find a new employer in H-1B status, or depart the United States. Now, I do want to give a caveat to that because I don't think that this is explained enough. That 60
Mhm.
days, it depends on how much time is left on what's called your I-94. It's
Okay.
either your I-94's expiration date or 60 days, whichever's longer. So what I mean by that
Okay.
is because I had a case recently that I was looking into where the person was terminated on, I believe, August 17th or 18th. And they were
Mhm.
talking about using the 60-day grace period. And I realized their I-94 was actually only good till the end of September. So
Okay.
they had less time than they realized. But traditionally, best case scenario, you get the full 60 days because you've got time left on the I-94. So that's where you have the opportunity to look for new employment, change status to another status, or depart. Best case
Mhm.
scenario typically is you find a new employer. You have them file the H-1B for you. Again, always factoring in that it takes 7 days for a labor condition application to certify. So being cognizant of that and realizing, like I tell everyone, 60 days is really 50 days because you need to bake in time to get that case
Yes.
filed and received by USCIS. So you have that period. Sorry, you have that grace period to use, but remember that it's shorter than you think it is. The other option, changing status. You can change maybe to a dependent status if you have a spouse that's on maybe an H1 or an L1, an F1. You have those dependent statuses as an option. The other
Mhm.
options are moving to F1 as well. You could also maybe look into, if you have to, filing a B2 extension to give you more time to maybe try and locate an employer. You will get into a messy situation where you're going to have to file,
Okay.
change your status to B2, change your status back to H1B. And you basically ask the service to adjudicate those in tandem, to approve and then approve, but it's always at the discretion of the service. You could see a situation where the service denies the adjudication of the B2 to H1 because the B2 hasn't been adjudicated yet, and maybe you end up having to go abroad to actually utilize the H1B. But
Mhm.
those are all options for you. I would, I think I've said before, if you're tiering them, I think at tier one, you've got finding a new H-1B employer. At tier two, you've got changing status. And then at tier three, you've got departing the United States. But at the
Mhm.
end of the day, even if you do have to depart the United States, you've already gone through the lottery and had an approved H-1B. So you're
Mhm.
not having to deal with that. So you
Okay.
should have an easier time finding a new employer and coming back into the United States. The biggest thing I would say, do not violate status. Don't stay longer than you're entitled to, and don't perform unauthorized work.
Okay.
Those violations are serious violations that carry consequences, especially in the
Mhm.
future when you're applying for a visa abroad. But that's pretty much it. If you guys have more questions on that or a specific situation, please feel free to send an email. We can even go so far as to set up a consultation if needed.
Absolutely. So thank you, Anabia, and I hope that was very helpful. I like how you put it, Justin. Thank you for taking that up as well.
Mhm.
Now we have Megha. What are the implications for my immigration status and future work authorization? Okay, but she's telling us more about her. I am an H-1B visa holder, and I've recently gotten married to a U.S. citizen. Can I apply for a green card while still working on my H-1B visa, or do I need to switch to a different visa category?
No, I think I don't see any problem with being on an H-1B visa. That's fine. It's a dual intent visa. You can
Mhm.
you can have the intent to immigrate permanently on an H-1B visa. So I don't think you have any issue whatsoever. I think it's a very common thing for people on H-1Bs to get married to U.S. citizens. Um, so yeah, I don't see any issues. If you want to file in the future. I think general with filing adjustment of status going for a green card. I try to tell people stay on your non-immigrant status, even if you get that EAD. It's just a rule of thumb. I like to think that just in case something bad happens, you don't marry yourself to the EAD. But anyway, I'm getting really into the weeds. Basically, I'm telling you, I don't think there should be any issues. I think you should be fine.
No issues, Meghna. You can go ahead. All the best. And now we'll take up, I think, Ishwar's question. We haven't taken that up. This is, I have a visa interview in Chennai in September 2024, and I will be traveling along with my 4-year-old kid. I don't have any friends or relatives in Chennai to take care of my kid. Can I take my 4-year-old who is a US citizen with me for the interview?
I mean, I think you would have to look at the rules that the consulate's posited. There are definitely consulates that say they're not supposed to be kids below a certain age there. So that's all
Mhm.
dependent on what the rules of the consulate are. I can't pretend to know the rules of every consulate. I
Mhm.
definitely don't know Chennai's by heart. So I would just check. And I think even if there's, let's say hypothetically there's a rule saying, you're not supposed to bring kids under a certain age, I would assume if you're able to contact the consulate, they might make an accommodation for you in the event that you have no other options. I mean, if you literally have no one else available to watch your child, then what's the alternative? You can't attend the visa interview. So I would say just talk to the consulate, try and work with them, see if there's a workaround if they say kids aren't permitted. As long as there's no rule that says kids aren't permitted, then I don't think there'd be an issue. But again, it's consulate specific. I've seen consulates say like you don't have to bring kids, and I've seen consulates where, if I remember right, the language is more akin to like don't bring people under age of whatever.
Mhm.
You have to talk to the consulate specifically. Sorry. Um, if I ever do learn the answer to that, I will share it on here
Okay.
though, because I
Thank
might
you so
I
much,
might go
Justin,
look
for
at
that.
it. But yeah, just talk to the
Yes.
consulate.
Cool. Ishwar, thank you for your question. And Justin, thank you for taking that up. And we have Anavia, who you just answered, saying, thanks, Tony. Got my answer. Thank you, Anavia, once again. And Justin, I think we are coming to an end. We have taken up, I think, all the
Yeah,
questions from my audience as well. So we
I
should
think I'm
wrap up.
talked out.
Yeah, all right. But thank you so much. It's been great chatting with you and for all those. I mean, it was a great discussion. We had very interesting questions as well. And
Mhm.
what do you have to say to wrap up? Anything about H-1B?
Um, that was a pleasure being on. I don't think we really talked about concurrent H-1Bs at all. I mean,
Okay,
it just
so
didn't
why
come
not
up.
say a little bit?
There were no
Yes,
questions about it, but not concurrent. I'm sorry, CAP exempt employers.
cap exempt.
But
Yes.
yeah, CAP exempt employers is another avenue for H-1Bs if you're not selected in the lottery. Just something I've been talking about recently. Concurrent employment H-1Bs. Concurrent employment H-1B, like if you're going to a cap subject. I'm sorry, I'm talked out. Long story short, look into if you did not get selected into the lottery, possibly working at a cap exempt employer. Those are typically going to
Yes.
be research universities, healthcare that's affiliated with schools and universities, nonprofit organizations, stuff like that. And
Mhm.
that's pretty much all I got.
Okay. Thank you so much, Justin. I think, you totally deserve this long weekend. You seem to have worked a lot, and I'm sure, like we discussed earlier, you have these very complicated cases. You do a great job. So congratulations, and thank you for joining us once again. It was great having you here today on this discussion.
Yeah, thank you so much for having me. It's always a pleasure. You guys all have a great weekend, and I'm sure I'll be back on again in the near future.
Me too. Hoping to see you in the coming week. Bye bye,
All right,
Justin. Have a
all right,
happy weekend. Bye
you
bye.
too.
Thank you, friends. And you feel free to contact Attorney Justin Rivera. His details are on the screen. You can call him on this number, 844-592-7336. Once again, let me repeat, 844-592-7336. You can email Justin at support@wasden.law and go check out wasden.law to get to know more about Wasden immigration litigation and also Justin Rivera. And also, don't forget to follow Wasden Immigration Litigation on LinkedIn for more immigration updates. and also us. We are Immigration and Jobs Talk Show. If you resonated and you are into immigration, an immigration enthusiast, why not subscribe to our channel, hit the bell icon, and you will always be notified when we have discussions like these. Furthermore, you can also contact me if you have any questions regarding immigration or jobs. And also remember that we also sponsor H-1B visas. So feel free to contact us. My number is 408-335-6444. And my email address is neep@higherightpeople.com. And to get to know more about us, check us out on www.higherightpeople.com. This is it for now, but don't go anywhere. Stay tuned to our space because I'll be joining you again in another hour with another webinar and uh, another guest. So it's going to be very interesting. Thank you so much for joining us. Bye-bye for now.
Consultant seeking a new opportunity? We offer job placement services for US citizens, green cards, EADs, and visa holders. We also sponsor various work visas like H-1B, E3, TN, and green cards. 20 plus years of experience in the industry. Exceptional employee benefits. Highly rated by our employees. Global presence with 200 plus recruiters and direct clients. Connect with us. Call us in the number 408-335-6444 or mail us at neep@higherightpeople.com or visit our website www